Hi everyone, my name is Casey Ballou, and tonight I'm going to be talking with you about Criminal Code number 17C specifically. This is applying to the Federal Rule of Criminal Procedure. For my sources, I have used Cornell Law School, the Federal Rules of Criminal Procedure 2017 edition, and a blog about the battle over the scope of Rule 17C. This topic specifically covers subpoenas. So first I want to read to you the three different parts of 17C and what it is used for. If you don't catch it all, that's okay. I'm going to go over each subtopic independently. This rule was basically made to make trial go faster. The purpose was to get each side to give up information that they had so that during trial it didn't have to be paused or stopped, so that each side would be able to have time to look at and review information. And that way this could get done prior to trial and make things go faster. So real quick, I'm going to read the rules. And again, if you don't understand it as I read off the rule, that's fine. I'm going to go over each subtopic. So Rule 17C, number 1, in general, a subpoena may order the witness to produce any books, papers, documents, data, or any other objects the subpoena designates. The court may direct the witness to produce the designated items in court before trial or before they are offered into evidence. When the items arrive, the court may permit the parties and their attorneys to inspect all or part of them. Number 2, quashing or modifying the subpoena. On motion made promptly, the court may quash or modify the subpoena if compliance would be unreasonable or oppressive. Number 3, subpoena for personal confidential information about a victim. After a complaint, indictment, or information is filed, a subpoena requiring the production of personal or confidential information about a victim may be served on a third party only by court order. Before entering the order, and unless there are exceptional circumstances, the court must require giving notice to the victim so that the victim can move to quash or modify the subpoena or otherwise object. So like I said, I wanted to go over each part with you. So number 1, this gives a description of when and what the subpoena can be used for. It says that it can order a witness to produce books, papers, documents, data, anything else that the court sees fit. It says that it may have the witness produce them prior to trial or before the item goes into evidence. So this is where it is producing the stuff, right? Number 2 talks about quashing or modifying. Now, we all know what modify means. It means to change. But what does quash mean? Quash means to actually stop or get rid of. So to quash it is to make it go away. Point 3 talks about personal confidential information. This is really important, and I really like this point because it definitely gives the victim some privacy and some options. So what it does, it talks about where a third party may be subpoenaed to give information about a victim without the victim's knowledge. And so this subpart of 17C says that in order for confidential information, and this might be information relating to medical records, school records, anything that is private to that individual, it says that the victim must be notified prior to information being given out so that the victim has opportunity to quash or modify the subpoena themselves. So I really like this part because it does give that victim some options whenever their personal information may be given out to court, which would be put into public record. So a few of the notable cases that this specific rule does apply to is the Bowman Dairy Company v. the United States and United States v. Nixon. So when we're talking about Bowman Dairy Company v. the United States, the Bowman Dairy Company was actually indicted for violating the Sherman Act. And like me, if you don't know what the Sherman Act actually talked about, it talks about the legalities involving monopolies. So the Sherman Act makes sure that monopolies do not have any sort of malice behind them. So what the Bowman Company did is that they were this small little dairy farm, and they started buying up a lot of dairy companies. So when that happened, some stuff came to light, and the United States government decided to indict them based on a violation of that Sherman Act. So what happened during this lawsuit was the Bowman Dairy Company, actually before the trial began, filed against the United States government, asking and subpoenaing their information. And the reason this became such a big deal is because, excuse me, the United States did not want to give up this information. This information was, some of it was protected by something called the Work Product Doctrine. And if you're not sure about that, that is something stating that anything that the United States created in defense or in prosecution of this company, they don't have to give up. And this kind of entails memorandums or any information that they actually produced. So another reason that the United States government didn't want to give them information is because they actually had government spies inside of this company feeding them information. And what that would have done is it would have given up the names and information of these confidential informants inside of this company, which would have compromised a lot of people within the United States government. So another reason this didn't work out was because the Bowman Dairy Company did not give necessarily specifics. It was basically seen as a fishing expedition. They were fishing for information. They just really wanted to try and find anything that the government had so that they could find evidentiary proof, which was impossible because of the verbiage and the way that it was put out. So next, during the United States versus Nixon case, I can't tell you how much information is out there. This is the Watergate scandal, right? This is the big, huge Nixon case. This is the reason he lost his presidency. So during this case, it's basically put out that Nixon was a co-conspirator of a crime. The grand jury indicted him of being a co-conspirator. And what kind of took place was he was in conspiracy with a group of people that committed a crime against the Democratic National Convention. And he knew about it and he was part of it. So this is a huge piece of, huge piece of law. There's a lot of documentation. There's a lot of video, and I can't go too much into it. But during the trial, of course, he was named as a co-conspirator, and they produced a subpoena for Ducis tecum. And that is a Latin way of saying stuff. We want the stuff that goes along with it. We're not asking for testimony necessarily. We're asking for stuff. So Ducis tecum is evidentiary documentation, which kind of includes data and videos and recordings and stuff like that. So the reason this became such a big case was because if he were to give that information, he would be giving his truth away. He would be giving over to the other party everything. So he would, in doing so, would be making sure that he was found guilty. This is a huge detriment to him personally. This is a huge detriment to the presidency. So this is why this rule played such a big part in that criminal case. So even now, they make sure that they hold this rule to the utmost standards and make sure that things are followed very strictly because of this rule, because of the Nixon case. And there's actually something called the Nixon standard. So whenever excuse me, this case is put, or this rule is put into play, they make sure that they use the utmost standards when dealing with this. So that way there's no coming back and saying that, well, this person had to give up information that would overall take away their liberty. So they're very stringent rules. And some of the rules that came about were basically saying that in order to use this rule in this subpoena during a case, there must be relevance, there must be admissibility, and it must be specific. So we have to make sure that this rule, that the information that we're subpoenaing is relevant, it has to be admissible in court, and it has to be specific. We can't be just searching for any information, we have to be specific whenever we're asking for information via this specific subpoena. So what I want to do right now is really quickly share my screen so that way you all have a kind of an idea of what the subpoena looks like itself. And this is just a template. It says the United States District Court, and it is just a template. So whenever I was mentioning this, I forgot to tell you that there are a lot of caveats that go with this. There is a lot of if this, then that, or if that, then this. So there are a lot of different small little caveats that go with this, and some of them have something to do with servicing, and some of them have to go with witness pay, and we're going to see that on this subpoena template. So you're going to see that it's United States District Court. You're also going to see that you know, we have to give a place and a time and date of when we were expecting this information, so that way any victim can go ahead and file a motion or file a quash to get rid of the subpoena, and give that time so they know the time frame of the information. We also have a proof of service, meaning we have a proof that this was given, this is when and how it was given. And we also have something on here that talks about pay. So say you have a witness that, and you're in New York, and we have a witness that lives in California now. We can't expect them, because the court told them to fly across the United States and spend all this time and money just to give testimony. We can't expect them to do it for free. So what this does is that it compensates them. So we have the fees for a witness, we have the mileage for a witness, and we have the total for services, and that way that they are compensated for their time and effort and funds whenever they are traveling to give any sort of information. And then of course all the relevant signatures. So this is the information I have to give on Federal Code 17C. So if you have any questions, please let me know. Other than that, I hope you enjoy this presentation and have a great night.